Okay, so let us resume. I was just saying, for those people online, I was just talking about the fact that I was very privileged to serve South Africa as an acting judge in the Constitutional Court, and that has provided an opportunity for me to reflect on those experiences. And tonight is my first foray into that reflection. So I want to talk about the deliberative practices of a court can be divided into three phases. This is following the work of Conrado Hubner Mendez, a brilliant book called Constitutional Courts and Deliberative Democracy. And those stages are the following. The first is the stage before judges are required to decide, where the papers are lodged and the hearing itself. The stage during which judges reflect, engage, decide, and write judgments. And then the stage at which the judgment is released. And this includes both the accessibility of the judgment to the public, for instance, media summaries, and the reception thereof, what effect it has on the deliberation in our society more generally. Now, the focus of my discussion tonight, although each of these stages requires a lot of thinking, and I think there's been very little engagement about that in South Africa, each stage implicates multiple values. My focus is going to be on that second phase and what I call the internal deliberative practices of the court. And that refers, for clarity, to what takes place after a matter is heard and before a judgment is delivered. So what am I going to do tonight? In the first part of the presentation, I'm actually going to describe the current experiences of the South African Constitutional Court in relation to the internal deliberation as I experienced them. Actually, they're not so well known, and so I will describe some of them. In the second part, I will then argue from a more theoretical perspective why it is desirable for the Constitutional Court of South Africa to adopt practices that encourage significant deliberation between its members. The last part of the paper, I will seek to examine advantages and disadvantages of key aspects of these current practices in light of the normative framework that I have outlined. And my goal with this reflection is humbly to suggest ways to improve the internal deliberative practices of the Constitutional Court. And I shall conclude with some recommendations in this regard. And I should say my goal is not in this to undermine the court in any way, but rather through academic reflection to help enhance its ability to perform the vital role that it does in South African society. So what about the deliberative practices of the court itself? Well, we first have to look at some of those institutional features. It's a multi-member court, as people know, of 11 judges. A matter must be heard by at least 8 judges. All judges can write, but that rarely happens, unlike some other courts around the world. And usually there is a clear majority decision on the reasoning and the outcome, with concurring judgments on some aspects of the reasoning or a limited number of dissenting judgments. And former Justice Catherine O'Regan said the following: taking the plurality of issues into account, it is something of a miracle that an 11-member court can ever produce a unanimous judgment. But it does. So how does this process unfold from the hearing of a matter to the release of judgments? What process takes place between the judges? And is that process, as it currently is instantiated, desirable? Well, much of what takes place between the judges is confidential and so quite mysterious for the public. Now, that's not the case, by the way, in all jurisdictions, but the processes that take place behind the scenes in deciding particular cases in South Africa have been regarded as confidential. And so I will not tonight in any way break that confidence in relation to particular matters. However, given the massive power conferred on judges of the Constitutional Court to strike down laws of Parliament, the conduct of the president, and to in fact mold the entire legal system, the broad contours of the internal processes of judging is a matter that should, in my view, be subject to academic reflection and broader discussion. Now, my focus tonight will be on the collegiate decision-making process. While there's very little academic discourse on this topic, some judges, for instance, Catherine O'Regan, Dikha Moseneke, and Albie Sachs from the First Court, have shared their own experiences and reflection on various aspects of the process of judging. Well, I know former Deputy Chief Justice Moseneke straddled the boundaries between different courts. And some of their reflections will help compare the current practices I experienced with those that existed before, particularly in the days of the First Court. My focus tonight will not be on the process of decision-making as an individual judge, of which there is, of course, a lot to say, but rather on the process of decision-making as a court with multiple members, what I shall refer to as a collegiate court. I will lay out the generalized practices initially as I experienced them, and there are subtle variations which I won't address. And we'll see later on that there have been changes over time. I'm also going to focus on matters that are actually set down and heard and not new applications, leave to appeals, of which there's also a lot to say. So there's an example. That's in the second term that I was sitting. Those were the judges who I was sitting at, wonderful colleagues, and that's what I mean by a multi-member court. All those judges are going to arrive at a decision in a particular matter. So what are the stages of judicial deliberation? The deliberation of judges includes the following elements: pre-hearing consideration of a matter, engagement with counsel at the hearing, the post-hearing process of the individual judge, the interaction between judges post-hearing, and aggregation into a limited number of judgments. So the account of internal deliberative practices of judges must begin, prior to the hearing. The process starts when the Chief Justice determines the role for the following term and assigns judges to write the judgment in the case. Once the record has arrived in the chambers, each judge is required to read the record. The Constitutional Court has not had case lines, which is an electronic database of cases, and I believe that is changing. And so the records which I received were generally in paper form. After a thorough reading of the record, my practice was to identify important questions that I wanted to engage with in the hearing, and I would also ask my clerks to prepare some initial research on some of the key questions I had identified. And the scribing judge's clerk, so the judge who's been assigned to write the judgment, takes responsibility for a clerk seminar on the topic. And here I want to give a shout out to my two initial clerks, Laura Johnson and Mbulelo Mango, and also then subsequently to Mila Harding, Buyani Nzishe, and Caitlin Turok, who all worked with me, and there's still an outstanding judgment on which they're working with me. So many judges have a preliminary discussion about the key issues and what questions should be asked at the hearing. I asked my clerks to raise issues as they saw it themselves as well, and also after reflection at the clerk seminar. That seminar is an important moment for deliberation amongst the clerks and has the potential to feed into the thinking of the judges. And there's a whole little bit, which actually an area of research about the impact of clerks on judges, etc. And this is something really interesting also worldwide to look at. The pre-hearing discussion involved some engagement about the key issues, but is focused very much on preparing for the hearing. Now, the hearing is an important moment to test the judge's thinking about the issue and also to press legal representatives on underdeveloped arguments. A judge may also engage with additional issues that may arise on the papers and request the perspective of the legal representatives. The hearing is also an opportunity for each judge to indicate to the other judges some of their concerns. The hearing does not involve discussion between judges, but the questions asked are an indication of the initial approach to the case of some of one's colleagues. And no meeting of judges takes place before the hearing, and so questions can in fact overlap and show some kind of commonality of thinking. Now, it's also interesting to note that there is no meeting of judges currently after the hearing. Whilst there was no communal post-hearing conference, in line with what a number of permanent judges recommended to me, I developed the practice of meeting my clerks immediately after the hearing. I would express my initial thoughts on the topic and the key questions involved. I would outline some of the key reasoning I was considering and responses in relation to the arguments made in court. My clerks would take down notes, interact with me, and challenge me. I would ask them to take contrary positions to those that I initially adopted to test my own positions. And then I would produce a short document indicating where I provisionally stood on the key topics. The formal process after that involves the scribing judge being required to develop what's called a post-hearing memorandum 1 week after the hearing. The post-hearing memorandum indicates the position of the judge in relation to the reasoning and the remedy. The memorandum is sent via email, and there's usually about a week, sometimes more, depending on the busyness of the court, devoted to responses from colleagues. It is important to note that at this stage, colleagues are not required to respond and indicate their positions. All communication also takes place via email and in written form. In relation to cases where there is a strong overlap of thinking, there will be widespread agreement on the approach to be adopted by the scribing judge, and there may be some responses raising certain nuances which are to be modified. In other cases, it will be clear that there are differences around reasoning or remedy, and these will be given expression to. After the initial round of comments, a deadline is usually set for a first judgment to be produced by the scribing judge. Judges do on occasion speak to each other directly and individually about judgments, particularly if there's an alignment and people want to sort of engage a little bit more informally. Now, an important recent addition to the process was the introduction of a step whereby 2 judges are assigned to provide input on the work of the scribing judge. The process usually unfolds such that the scribing judge sends a draft judgment to these 2 colleagues who provide initial comments to the scribing judge. The judge then considers these comments, makes the modification he or she wishes to, and then releases a draft first judgment to the rest of the colleagues. This change ensures that a scribing judge has at least 2 colleagues who have a special responsibility to provide comments on their judgments. The usefulness of this process depends really on the nature of the comments that you get. Some of the time the comments are substantive, and that's where it's most useful, and other time more of an editorial nature. Now, from that point, there are 2 scenarios that will happen. In relation to cases where there are limited disagreements, there will be an opportunity for judges to comment on the first draft judgment. There will then be an opportunity for the scribing judge to revise it. And where there is limited disagreement, the revision may be what is referred to as a read-through draft. Read-through is a process where a judgment is considered in a meeting of judges. And it is the first face-to-face meeting of judges on the case after the hearing has taken place. Technically, it does not involve the reading through of every single sentence. That's what I thought it sounded like initially. But rather, the judges in the meeting go through the judgment paragraph by paragraph, with the judges raising formulations, issues of language, and occasionally substantive points. After the read-through, the scribing judge usually needs to approve the changes that were made, and then the judgment enters what is referred to as clerk's processes. Clerk's processes involve a detailed language and reference check by the clerks. The clerks then send their suggested changes to the scribing judge, who decides on those he or she wishes to adopt. A final judgment is then prepared together with a shortened handout note, as well as a media summary. A date is set for hand down, and the judgment is finalized and handed down in court by 1 judge or more, as it's also possible for that to happen. The second scenario is one where there is a complexity given disagreement around the reasoning as well as the remedy. Once the first judgment is released, during the opportunity for comments, it will become evident whether there will be a need for concurring or dissenting judgments. There may be several judges who disagree, and there is no formal process to decide who actually writes a further judgment. Further judgments are written by those judges who feel strongly about a matter and often are decided informally. The lack of a formal process in this regard means that some individual judges who wish to dissent on several matters may have to write many more decisions than other judges. A deadline will usually be set for the additional judgments. There is then an opportunity for colleagues to provide comments on the dissent or concurrence. After comments, there is a time period set for the revisions of the concurring or dissenting judgment, as well as an opportunity of the scribing judge to consider their response. A date will then be set for read-through, but again, even though there is a face-to-face meeting, it does not generally involve a discussion of the substantive differences between the judgments. And an important point, which I'll come to later, it is not necessary for judges at any stage to make it clear where they stand, even at read-through. And thus, there are some cases in which it was very unclear until the very last minute where the majority or the minority lies. After read-through, a similar process is undertaken with the several judgments as described. Clerk's processes take place, and a period needs to be left for the consolidation of the judgments. Thereafter, judgments are finalized, media summaries are prepared, and the judgment is handed down. So what are going to be the focal points of my discussion tonight after describing the process? I mean, the first thing to say is I think it's interesting to describe the process in itself and to illuminate a little bit about what happens behind closed doors and to see the detailed care and consideration that goes into the producing of a judgment. There are, however, aspects thereof that I wish to analyze in more detail. The substantive point that I'm going to look at in what I call the substantive frame of deliberation is what's not evident from the discussion that I've so far laid out is what are the substantive matters on which the judges deliberate. And the issue I want to focus on is, can judges raise matters miro motu, or of their own accord, and engage with arguments that are not raised directly by the parties themselves? So that's the substantive issue that I want to consider. The procedural issues I'm going to focus on are the following: the lack of any post-hearing conference, the lack of face-to-face engagement, and most of the engagement being via email, and the lack of any requirement for judges early on to indicate their thinking, and when dissents and concurrences emerge and are written. But before examining these practices in detail, we need to have some basis upon which to evaluate them. So it is to that matter that I now turn. So in this segment, I will consider how judges should decide matters as a collegiate court. And as I mentioned, there are a range of practices across the world which correspond to various jurisdictions. There are jurisdictions like Brazil, where judges do not confer at all, and publicly each go read through their own judgments, and suddenly colleagues know about what the other judge is thinking only at that point, right? Very interesting model. There are cases where judges confer, but still all release separate written opinions, and many of you will be familiar with the former House of Lords, and that was very much the practice, right, that used to occur. There are examples where judges confer and there are a limited number of opinions being released. Sometimes there's unanimity, but other times there are concurring and dissenting judgments permitted, and that's the South African approach. And judges, in other cases, judges confer and only one opinion is released. This is very much a model in Europe. The French Conseil Constitutionnel, for instance, even if there's dissenting, you're not allowed to dissent. There has to be one judgment that is issued. And so this shows us that there are different practices around the world, and it raises the question, how ought judges to decide a matter as a collegiate court? Is there a better or worse way? Why, for instance, is it good for judges to confer and not simply release their own separate written opinions? I will focus tonight on the desirability of deliberation, and particularly how that relates to South Africa. The case for deliberation will be utilized to evaluate the manner in which deliberation currently takes place. And given the limits of time, I cannot develop all these normative points in full detail. I am working on a paper, and so I'm simply going to seek to outline the normative case involved. So the first important point is, what is deliberation? Michael Walzer, many of you will be familiar with, is a famous philosopher who captures the nature of deliberation as follows in the context of a democratic parliament. He states that it is about reaching decisions through a rational process of discussion amongst equals who listen respectfully to each other's views, weigh the available data, consider alternative possibilities, argue about relevance and worthiness, and then choose the best policy for the country. Walzer argues that deliberation is very different from debate. Says, for those debaters out here, debaters do have to listen to each other, but listening does not produce a deliberative process. Their object is not to reach an agreement among themselves, but to win the debate and to persuade their audience that this position, rather than any of the alternatives, is the best one. A debate is a contest between verbal athletes, and the aim is victory, which is perhaps why I always felt a bit uncomfortable about debating, even though I liked it. What are the key characteristics of deliberation in courts? And here I'm going to outline and follow the account of Conrado Hübner-Mendes. Deliberation, he says, is a means to arrive at authoritative decisions that command obedience. Deliberation involves participants providing reasons for their decisions to each other. It comprehends, he says, an exercise of mutual justification that allows a thorough type of dialogue before a collective decision is taken. There are also substantive constraints on deliberation. Only reasons which all members could reasonably accept are compatible with deliberation, and appeals to private interests, for instance, cannot succeed. People have no reason to accept a claim that a result that will enrich one personally is a ground to vote in favor of that result. Deliberation involves reason giving that is actually intended to spark an interactive engagement in which deliberators try to persuade each other. Persuasion involves 3 steps, he says. Participants are willing or open to listen to each other and revise their initial points of view. There is an ethics that is desirable to reach consensus underlying the decisions, and there is no coercion. And deliberation proceeds from a position of equal respect for all those who take part and are affected by it. And the aim is to consider and include different opinions, to be alert to points of view absent from the discussion, and to respond to counter arguments. So with this in mind, why is deliberation valuable for a multi-member court? I'm going to consider 4 arguments: an epistemic argument, a culture of justification argument, an argument from African moral theory, and an efficiency argument. First, the epistemic argument. And for those not familiar with philosophical terms or legal terms, epistemic means relating to knowledge, and in this case, the reasons for decisions. Deliberation, as we saw, is a process of reason giving, discussion, and persuasion, engaging with multiple perspectives. And it can achieve the following benefits. It can expose key premises in arguments, it can enable the gathering of relevant information, and it sparks creativity as solutions are reached that individuals alone would not come up with. In the words of the philosopher John Elster, it involves the transformation rather than the simple aggregation of preferences. Ultimately, it also can improve reasoning and the likelihood of coming up with the best possible reasoning and outcomes. Deliberation is also important instrumentally for multi-member courts because of its ability to maximize agreement. A multi-member judicial body, by its nature, must try and ensure coherence in its reasoning and guidance for future litigants and courts. It must also seek to arrive at a remedy. As such, deliberation can play an important role in enabling judges to find common ground and arrive at a common decision. A deliberative process can also allow for areas where compromise is possible to be identified and prevent splintering into too many opinions. And where there are disagreements, it can also sharpen the points of disagreement. And we have some anecdotal evidence from some of the judges who've written about this in the South African Constitutional Court that they see these benefits as having occurred. So in former Justice Catherine O'Regan's account, the process of deliberation at its best refines issues, improves legal reasoning, and renders just outcomes more likely. As a result of the process of deliberation, a draft judgment may change dramatically from when it was first written to its final form. She also outlines what she says is the most important justification for requiring diversity on a collegial court is that it enables members of the court to interrogate their own prejudices or blind spots. And she suggests that the more different individuals are, the more they are able to interrogate the correctness of others' assumptions. Justice Sachs, who I believe I think online, and thank you very much for joining, in his wonderful book, The Strange Alchemy of Life and Law, he says regarding deliberation amongst colleagues that we perpetually stir in new ideas, different approaches, and elements of undue personal subjectivity subjectivity vaporize quickly in the cauldron of argument. When the judges deliberately state that we can engage with each other in the intense and distinctly earnest deliberative tones that only jurists and perhaps some clerics use, you can almost hear our brains whirring as one by one we motivate our different standpoints. It is in a setting of rigorous intellectual interchange, any initial preferences that we might have started with would at least have to be artfully dressed up in the garb of plausible legal argument. And so this account indicates how deliberation can help shape each judge's decision-making process, challenging premises, exposing biases, and enabling innovative legal reasoning. Second argument I want to go on is related to the famous contribution of Etienne Muranic about what the transformation, I titled this talk Transformation, what the transformation is meant to occur in the South African legal framework. And I'm influenced very much by him, and he said that one of the goal of that transformation is to transition South Africa, it's not the only goal, of course, from a culture of authority to a culture of justification. A culture of authority is where a decision is justified simply because it emerges from a particular source that is authorized to make the decision. A culture of justification recognizes the validity and legitimacy of a decision rests on the substantive justification that can be offered for the decision. Now, I do not have time to develop this argument in detail, but in my view, the creation of such a culture is not just about the duty to give substantive reasons, but also about the process through which such reasons are reached, such decisions are reached. Okay, so why does the process of decision-making matter to the very idea of creating a culture of justification? Well, I want you to imagine a scenario where an individual judge writes an excellent judgment and presents it to his or her colleagues. There is one premise in the argument that the other judges found troubling and wish to change. The particular judge simply refuses to change any aspect of the judgments and asserts that he is an authority in that area and the other judges should simply follow his reasoning. In such a scenario, the judge is not seeking to persuade the other judges, but relies on an assertion of superior knowledge or authority. Such a scenario, in my view, does not represent a commitment to justification, even though reasons are provided, but to a brute assertion of authority. The culture of justification is also designed not simply to be entrenched by the legislature and executive. The approach to justification adopted by the judges very much frames the culture of justification in South Africa. If judges see themselves engaged in a common practice of justification that must permeate across our society, that practice must inform not only how the judiciary relates externally, but also, in my view, to its practices internally. Doing so, once again, involves requiring an openness to engage about any reasons provided by another judge and to revise in light of any challenges that cannot be answered on a satisfactory or substantive basis. John Rawls, famous philosopher, regarded the judiciary as what he said was the exemplar of public reason. In my account, they would also be an exemplar of what it means to entrench a culture of justification. And that requires thorough acceptance of deliberative practices. The third argument relates to the question, what approach to decision-making is particularly appropriate to South Africa? Sadly, last year, one of our pioneering justices in South Africa, Justice Yvonne Mogoro, passed away. The argument I make here takes seriously an important argument she made in the Makwanyane case relating to the death penalty. When courts engage in constitutional interpretation and promote the values underlying the Constitution, they should, she said, consider the relevance of normative indigenous South African values. This is important as it is a matter of correcting for epistemic injustice, the marginalization, disregard, and distortion of African knowledge systems in South African judicial lawmaking prior to the advent of our Constitution. Justice Mogoro placed great store by the centrality of Ubuntu, which she argues is centrally connected to our constitutional order. The central aphorism she refers to is Umuntu Ngumuntu Ngabantu, roughly translated, a person is a person through other people. This saying has been seen to recognize the fundamental connectedness of people. Rather than being separated from one another, we become fully a person through how we are to others and through recognizing our responsibilities to them. This emphasis on relationality has been seen as central to much African moral and political philosophy. Without going too deeply into this philosophical approach, I would contend that it has important implications for the approach to be adopted to judicial decision-making in post-apartheid South Africa. Ronald Dworkin famously outlined the image of a super judge who's known as Hercules, who is outstanding, but in his solitary way seeks to find the right answer for every case. I'm simplifying somewhat here. But I would suggest the image of an isolated, brilliant Hercules is not appealing in the South African context and in relation to the values flowing from African moral theory. Instead, the relational ethos commends a modality of judging that involves individuals working together, sharing and conversing in the service of finding the best possible reasons and outcomes for a case. In his famous essay on some African cultural concepts, Steve Biko writes, "Westerners have in many occasions been surprised at the capacity we have for talking to each other, not for the sake of arriving at a particular conclusion, but merely to enjoy the communication for its own sake." He goes on to speak about communication as involving a desire to share. And that suggests that an ethos and love for conversation and working matters out together is part and parcel, a central dimension of African culture. What implications does this have for decision-making? Well, underpinning African moral theory is the importance of engaging with one another and working together to find the best reasons and outcomes. That process of engagement and deliberation involves an attitude of deep respect, but also a notion that what emerges from the deliberation represents a joint enterprise rather than a solitary exercise. I find compelling the idea of Justice Mokgoro that the values underlying our practices in the new constitutional order should be ones that have resonance and connect with our society. And it seems to me thus appropriate for South Africa to root its ethics of judging in such a relational African approach, which would place great emphasis on the value of deliberation. The last issue I want to cover surrounding deliberation is how it affects efficiency in the handing down of judgments. And here, when I refer to efficiency, I'm going to refer to what Leo Boonzai and Urina Ali call judgment processing times, the time between the hearing and the release of the judgment. Efficiency is an important value in relation to the operation of courts. Given, for instance, the Constitutional Court has to decide on the constitutionality of legislation, the longer it delays, the longer it can leave an unconstitutional statute in operation. Its judgments may also affect individuals in concrete ways, for instance, as to whether someone is convicted or acquitted, as well as whether someone can claim compensation in a civil case or not. It is important here to acknowledge a tension between efficiency and arriving at the best reasons or outcomes. The latter is the central duty of the court, and it should certainly, in my view, not arrive at suboptimal outcomes simply because it wishes to have a judgment released quickly. At the same time, it cannot ignore the importance of the value of efficiency. Now, here I'm going to refer to the groundbreaking work of Boonzai and Ali in relation to the judgment processing times of the Constitutional Court. In their first piece on the topic in 2022, they found that the average time between a hearing and a decision of the court has exactly doubled. In 2021, over 60% of judgments took more than 180 days to hand down from the hearing date. One of the factors they consider to explain this problem relates to judicial unanimity, and they clearly show that non-unanimous judgments take longer to produce. They conclude that the recent surge in processing times seems to be driven overwhelmingly by a slowdown in dealing with non-unanimous judgments rather than unanimous ones. They updated those statistics between 2022 and 2024 The court's average hand-down time was 214 days from hearing to hand-down. This was the slowest period rate recorded. 60% of cases took more than 180 days to hand down. And an interesting trend they found was that the number of unanimous judgments had increased in this period to 60 to 70% of the cases. But that had not been accomplished by a reduction in hand-down times. They, however, nevertheless demonstrate that the time taken to produce non-unanimous judgments is significantly longer. They conclude, in short, there is evidence that the time required to settle non-unanimous judgments is driving some of the worst inefficiency problems. So good deliberation takes time, and so you might be thought that it would impact negatively on efficiency. However, in what follows, I'm going to suggest that that is not necessarily the case, and that the manner and approach to deliberation matters. If some of the inefficiencies in the current process are corrected for, greater deliberation may in fact reduce rather than lengthen judgment hand-down times. So there we have 4 reasons to think about when we're evaluating the practices of the Constitutional Court itself. The first issue I'm going to go to is the substantive dimension of deliberation. Deliberation, as I've said, part of its benefit lies in the fact that one thinks together, and that can lead to shifts in reasoning and outcome. That immediately leads to the question, if deliberation leads to the identification of issues, reasoning and remedies that were not adequately ventilated at the hearing, can that in fact form the basis of reasoning in the judgments? And this raises the questions whether judges may permissibly engage with matters miro motu, which means of their own accord. The question is important as it relates to the substantive content of what can be deliberated upon after the hearing. And my experience was that this issue arose frequently, and judges among themselves often disputed what is permissible to engage with and what isn't. Now, in my research, I've broadly tried to lay out 2 approaches for simplification purposes. It's a complex issue, and there's a bit of a spectrum. The first is what I term a narrow approach, which permits a matter to be raised miro motu, for instance, where a point of law appears from the papers, but the parties proceed along an incorrect perception of the law. And this was held to be an application of the principle of legality itself. This dictum is quite restrictive as to where there is some mistake in the law itself. Another restrictive approach is that the parties must be given an opportunity on every occasion to respond to any points that judges may raise. This can occur at the hearing, but it also may occur after the hearing as well. Now, what are the foundations of the narrow approach? It's based strongly on the adversarial nature of our present legal system. And some advocates and attorneys press this, how important this is, right? It assumes that the parties lay out the basis for their case and the judges simply adjudicate the case. This system requires that each of the parties be given an opportunity to put their case and respond to the case of the other party. It is also premised on an assumption of the equality of the parties, that each is able sufficiently to put their case forward and address the contention of the other parties. There are several critiques that can be made, however, of this, some South African specific and some more general. The first critique is that the equality premise cannot be defended, in my view, in the South African context. Unrepresented individuals do not have an equality of arms with represented parties. And many judges place huge store by the mere fact that sometimes parties are, in fact, represented, mostly in the Constitutional Court. But the quality of legal representation varies greatly. Even at the Constitutional Court level, I can attest to the fact that there were very well-drafted submissions, but also to some very poorly conceived papers. There was also a strong variability in the quality of oral arguments. To force judges to be bound strictly to the pleadings or even the representation of the parties is to fail to recognize the variability of representation in the country and the unequal quality thereof. A second related reason for judges to consider matters miro motu, particularly in circumstances where vulnerable parties came before the court, is to ensure that when matters are squarely before the court, that they are decided. If a matter is decided based on a narrow view of the pleadings, then in order to have a closely connected issue finally determined, another person will have to commence a case in the High Court and will have to go through the hierarchy of the legal system again. Due to difficulties in accessing financial and human resources for those who are vulnerable, it makes sense for judges to determine important matters that arise from the pleadings, even if they have not been adequately addressed by the parties. And in the context of customary law, this argument is made in relation to the Mayelani case by Himonga and Pope. A third reason against this, the narrow approach is that one of the benefits of deliberation is that, in fact, that new ideas and approaches emerge in the deliberative process. That's what I laid out in the epistemic benefits. Arguably, this is one of the important reasons of having a multi-member court, to consider the representation of the parties and then provide the best legal reasons and remedy the judges collectively can develop. To shoehorn judges into being constrained strictly by the representation of the parties can lose this very important benefit of deliberation itself. And a final related reason, which of course courts are practical institutions, is a practical one. Issues often arise in deliberation after the hearing. To revert to parties on every single matter is simply not practical and will exacerbate the problem of efficiency. For example, Harms J.A. wrote that if the parties have to be forewarned of each and every finding, the court will not be able to function. So for the reasons given, a wider approach needs to be adopted. This does not mean, I should say, that a judge should determine a case that is not before them in any way. That would violate the separation of powers, as judges do not make law in the same way legislators do. Judges develop law in relation to cases that are before them and the concrete circumstances that arise. That raises the question as to what constitutes the case that is before them. Is it simply the case put forward by the parties or their representatives, or can one conceive of that case in a wider way in relation to the broader legal questions needed to resolve the dispute before the judges? Well, the judge's duty in the South African constitutional order, I would argue, is a substantive one, to do justice between the parties. It also includes wider duties to interpret legislation in conformity with the Bill of Rights and to develop the common law and customary law in light of the spirit, purport, and objects of the Bill of Rights. In constitutional matters, it includes a duty to respect, protect, promote, and fulfill rights and give effect to the Constitution and the rule of law. This constitutional ethos is one based on moving to a culture of justification and requiring substantive justification. All these duties suggest that the judges must ensure that the legal principles they utilize to address a particular case are coherent, provide a strong justification for the decision reached, and meet the substantive aims of the constitutional order. These goals in a particular case may well require judges to go beyond the exact submissions made by the legal representatives and decide the matter on what the judges regard as the most justifiable legal basis. Whilst in some cases it may be desirable to call for additional submissions, doing so is simply not practical if we recognize that deliberative practices will often lead to innovative reasoning and solutions to problems. These values argue for moving beyond a narrow substantive frame of deliberation to a broader but not unlimited one. And so it seems to me that a broader approach that is warranted would allow judges to engage with issues that arise from the facts and law in relation to the cases before them, even if the pleadings do not deal with them directly or in an optimal way. Particularly where rights are at stake or injustices can result, this also gives effect to the judicial duty to apply the Constitution and the law impartially and without fear, favor, or prejudice. And because of time, I'm going to not go through these precedents, but there is some support in the case law as well for a wider approach as well, I would argue. I want to now go to some procedural reasons and critiques of the process that I outlined at the beginning of this lecture. And I want to start with a published interview by Justice Cato Regan, who says that there was a conference immediately after the hearing where preliminary views would be expressed. Later, it became the practice to hold the post-conference hearing the next morning, she says. Later still, the practice developed that the post-hearing conference would be held after the writing judge had circulated a written memorandum identifying his or her preliminary views on the issues. And so clearly the judges were moving to having had a greater opportunity to consider their views before having a discussion of the issues. Currently, as I experienced it, there's no post-hearing conference. And this merits consideration in its own right. But due to time constraints, I'm going to focus on two other related procedural aspects: the lack of face-to-face deliberation and the lack of an indication where colleagues stand early on, and the process around dissent and concurrence. So in former Justice O'Regan's account, the court did not interact via email, but also had face-to-face opportunities for deliberation. My experience was that most engagement between judges happened electronically. It is no doubt true that email has become more dominant in our lives than was the case when the first court sat. However, I want to examine in a little more detail some possible reasons for this development, as well as some interesting social science in this regard. So social science literature has engaged with different modalities of communication. Media richness theory, which I can only sketch here, basically holds that email is very well suited for simple and direct communication about simple administrative issues, but is very well ill-suited to complex discussions and deliberation. Media synchronicity theory defines media synchronicity as the extent to which a communication environment encourages individuals to work together on the same activity with the same information at the same time, to have a shared focus. And this theory evaluates various media that we use, and it's really relevant to our modern world, for their ability to convey information as well as their ability to converge on shared outcomes. If one wishes simply to exchange information, there's no need for high levels of media synchronicity, it says, and email works well. However, to develop shared meaning from information, there is a need for high levels of media synchronicity, strong feedback, which is immediate. And the same is true if one wishes to achieve consensus. Face-to-face communication has the highest level of media synchronicity, but we can also think, for instance, of a Teams meeting or a Zoom meeting, which will have greater media synchronicity than simply an email. Now, what elements does face-to-face communication have that improves its performance in this regard? There's really a whole lot of interesting theory about this, but some of them are quite obvious and natural. You'll imagine the ability to convey and observe facial expressions. We might think that we only work through language, but we also are animals who have non-verbal cues, the ability to convey and listen to speech in certain ways. All of these things play a role in assisting in driving those outcomes. And so if the desire is to arrive at a common outcome, then face-to-face communication is clear from the literature is to be preferred. This theory may help explain the data that Buenzai and Ali have provided about the increasing number of divergent judgments that are occurring in the Constitutional Court, at least one fact in this regard. And if there is a desire to move towards a more consensus model of decision-making, then an approach that involves more face-to-face communication would be preferable. Now, an interesting thing is that I was trying to think of what reasons, why did this happen? And maybe one of the reasons I thought for the evolution of the court practice is the depersonalizing effect of email. Since colleagues in a court have to work together continually and judges often feel quite passionately about issues, face-to-face interaction can lead to a deterioration in personal relationships. Moving to email might help depersonalize any conflict. However, some of the social science literature suggests that the opposite effect actually occurs in electronic media. The fact of depersonalization often actually leads to more uninhibited behavior, which in fact increases conflict in a process that is being called flaming, which many of you will be familiar with from social media. As such, email communication may in fact exacerbate conflict rather than alleviate it, as was suggested. And it also may lead to less convergence. Another interesting dimension of email correspondence is that it is much more formal than face-to-face deliberation. As such, once a judge puts their views down in email, there is a degree to which that already represents their considered position. A communication in an email may thus render a judge less open to revision of their position, given they have taken a clear stance. Face-to-face deliberation allows for much less defined stances to be adopted and for a discussion where judges work out their approaches in relation to each other. A stance adopted in conversation is much more provisional and informal than one adopted in email. It also allows for clarifications of misunderstandings immediately, whereas email is much more prone to misunderstanding and also invariably loses some of the nuance as well as tone of expression. These features also render face-to-face engagement early in the process likely to improve efficiency in the production of judgments. Now, a counterpoint to these claims could well be that face-to-face interactions may have some downsides. There are personality differences between judges, and some colleagues may well be much more extrovert and come to dominate the conversations. Other colleagues may feel less able to contribute. In email communication, each person has an equal opportunity to deliberate and revert in their own time. Now, it seems to me that there is some validity in these concerns, but they can be mitigated. Different individuals can be tasked with leading the discussion at different times, and the Chief Justice can also draw in voices and ask for contributions by judges who have not spoken, ensuring everyone has the opportunity to engage. It does not seem to me that this is a definitive argument against face-to-face deliberation. The last issue I want to engage relates to, with this demise of the face-to-face deliberation, there is no requirement on judges to reveal where they stand at any point in the process prior to the last minute before the release of the judgment. That means it can only become clear where a majority or minority lies very late in the process. There is also no requirement for judges to disclose their own reasons for signing on to a particular judgment or not. And it seems to me there are several reasons against these practices. Firstly, some of the judges who sit on a matter are not participating in the process of determining the reasons and the result. That is normatively undesirable in that their perspectives could enhance the reasoning and perhaps even shift the ultimate result. If engagement only happens between a limited pool of judges, that simply impoverishes the general process. Secondly, at the apex court level, in many cases, who commands the majority really matters. Those judges that are engaged earlier in the process, including the scribing judge, may shift their positions in order to accommodate colleagues who are wavering or have particular strong views on the topic. If one does not know where a colleague stands, it is impossible to accommodate their views. Moreover, there are occasions where there are multiple splits between judgments. In such circumstances, an earlier indication of where other judges stand may influence other judges to shift their positions, or for instance, to ensure that the court reaches a determinate result rather than an indeterminate one. If several colleagues do not indicate where they stand, this also leads a scribing judge or other judges not to know where their colleagues are standing. If nuances of perspective were identified early on, that could already be included in the initial judgment writing process. And at present, since there is limited information that a scribing judge has about their colleagues' views, in cases of unanimity, nuances of reasoning and remedy only emerge sometimes later in the process. And that no doubt could provide another explanation of the long processing times, even in cases of unanimity. In cases of non-unanimity, matters are even worse. A scribing judge may be aware after the post-hearing memo of disagreement, but given there is no obligation to declare where one stands or to indicate one's positions early on, there is no indication of how widespread the disagreement is. At times, initial expressions of disagreement by few judges may attract no response from the scribing judge to change course. But as it becomes clear the disagreement is widespread, the scribing judge could change their position. Moreover, at present, a decision to write a dissent or concurrence usually occurs after a first judgment is written, which is many weeks, if not months, after the hearing. This approach, of course, has the benefit that the dissenting or concurring judge responds to a written judgment, but it is also incredibly inefficient, as it then requires time for the alternative judgment to be written. That judgment has to be commented on, and time for responses to be made to the first by the scribing judge. Now, I do not see many strong reasons for this practice, and the only reason I can really see relates to an overemphasis on the autonomy of judges to decide whatever they wish, whenever they wish. It also revives a much more individualistic approach to judging rather than a deliberative one. Now, there may be some practical reasons of time that a judge is completing another judgment and it's about to be handed down, that they will not necessarily be able to give reasons immediately. But a formalized process around this, it seems to me, requiring responses would, at specific times, would in fact address these issues. So in my view, this process could be improved significantly if dissenting and concurring judgments were written concurrently with the scribing judge's judgment. That could occur if there would be a restoration of post-hearing conferences, where clear alternatives were identified early on and individuals assigned the responsibility for writing alternative judgments. Even if that isn't done, if there's no more post-hearing conferences, but discussion continues via email, if it is clear whether individuals wish to write judgments, those individuals could be assigned to write such judgments concurrently with the scribing judge's judgment. That would eliminate the delay between the main judgment and a further month or two for the writing of dissents or concurrences. This approach would also help, I think, with a fairer allocation of the burden of writing dissents and concurrences. At present, the approach, as I described, is quite haphazard and depends on a judge feeling strongly enough to volunteer to write. There is no clarity amongst those wishing to dissent or concur as to who will write. If judges have to disclose where they stand and it becomes clear who agrees with whom, a better allocation of judgment writing can be developed. And there are often several judges who wish to dissent or concur, and it would be possible to really share out the burden of writing amongst them. That, of course, would also have knock-on effects on efficiency, given that all judges would have a more equal burden of labor, and so dissents and concurrences are not held up due to one or two judges being overburdened. So in conclusion, this talk has sought to engage with an under-discussed issue, the internal deliberative practices of the Constitutional Court. I first sought to describe the practices as I experienced them. I then sought to make a normative case for the value of deliberation in a multi-member constitutional court, such as our own. That case has suggested a number of important epistemic benefits of deliberation, but also argue that it gives effect to the very workings of the court, in the very workings of the court, to a culture of justification. Establishing deliberative practices also is consonant with the relational ethos in African philosophy, and so appropriate for South Africa, and may in fact enhance efficiency. After describing the existing practices of the Constitutional Court of South Africa, I sought to investigate both certain substantive and procedural issues with the current model. The way in which the court operates, I've sought to show, implicates a number of values in relation to deliberation and also has an effect on the efficiency of its delivery of judgments. I've suggested that the current approach is suboptimal, both on the basis of the value of deliberation for the judiciary as well as relating to its efficiency. In terms of reform, I would humbly suggest the following would help address the concerns I have raised. First, there should be the reintroduction of a post-hearing conference, which should take place no later than a few days after the hearing. Secondly, the conference should take place, if possible, face-to-face and in person rather than virtually, and if virtually, in a Zoom or Teams meeting. Thirdly, judges should be required to indicate early in the process their current thinking and reasoning so that other colleagues understand their positions. And that emphasis there is also on reasoning as well. And dissenting and concurring judgments should be drafted simultaneously with the scribing judge's judgment, which will shorten hand-down times in cases where there is disagreement. On the substantive frame of adjudication, I've argued that it should be permissible for judges to engage with any legal issue that emerges from the pleaded case, even if it has not been developed in detail in the written or oral submissions. Now, most of these changes can be attained simply through the revision of its current procedures by the Constitutional Court itself and engagement by the Chief Justice with these issues. At the same time, some of the procedures were put in place due to wider institutional questions concerning the surge in the caseload of the court, with the widening of its jurisdiction and its approach to deciding new applications en banc. To attain more time for deliberation, it would be necessary to address some of these wider institutional questions, which frame the context in which judges create internal deliberative processes. It is hoped that this talk will catalyze further thinking and scholarship about these matters, and that through doing so, we can not only enhance the quality and efficiency of our court, but also ensure that in its very own functioning, it gives effect to the transformative spirit, purport, and objects of our constitutional order. Thank you very much.
Well, thank you, everyone. And specifically, thank you, David, both for the presentation and frankly for being such a good sport earlier with all our technical delays. On behalf of the Dean, I have been asked to extend a note of apology for that. But unfortunately, we live at the mercy, at least, of technology in this instance. But in any instance, thank you, everyone, for making the time on a Thursday evening, as I said in the beginning, to come and to continue this tradition of hosting the Rabinowitz Lecture. We thank the family once again for joining us as well. And specifically, we thank our speaker, at least for sharing, hopefully, some controversial and interesting points of discussion later. We will be serving refreshments one floor down in the staff room. Please help yourself. There is wine available as well that has been questioned, and there is a vegan option, etc., for anyone ethically concerned.